Government has gazetted the new Property Practitioners Act, which was signed by President Cyril Ramaphosa in 2019. The regulations were approved in December last year and came into effect yesterday, the 1st of February. These regulations seek to transform the property sector as we know it. One of the biggest changes, according to the new regulations, says that if you are selling or letting a property, you must disclose all defects on the property to the buyer or the potential tenant before signing any contract. Joining us to delve into these and other changes is the Chairperson of the National Property Practitioners Council, Vuyiswa Ramokgopa. Vuyiswa, thank you very much for joining us. Well, let's start here. For consumers, people at home right now who are going to go out and look for property to rent or buy, there are some very important changes that are coming into effect, that have come into effect. Take us through those, particularly for property practitioners, and what consumers should know.
Thanks, Kalani, and thanks for inviting me to the show today. As a starting point, the industry has welcomed the implementation of the new Property Practitioners Act and the regulations. The original Estate Agency Affairs Act was effective in 1976, and as you can imagine, quite a lot has changed in the industry and in the country since then. So the new act really, it represents our current reality, and I think more than that, it represents our future aspirations as a sector and our aspirations for how we would like to engage with consumers going forward as a sector. And you've touched on some elements, and I think maybe I will just sort of highlight what we understand to be sort of four of the key standout areas. Number one, the Act seeks to broaden the scope of the professions and subsectors that are now regulated. What that means is that previously, only estate agents and brokers were regulated, and everybody else in the value chain was not regulated. And that presented a lot of problems in terms of, again, consumer protections, etc. So now the umbrella has been widened, the definition of what a property practitioner is has been widened, and we can touch more on that later. Number two, as we've said, consumer protections have been enhanced. You've touched on the issue of mandatory disclosures. That certainly is one area, and I think what's very interesting about that is that when a property practitioner actually gets a mandate from a seller, that mandate has to be accompanied by that disclosure, disclosing defects or any issue that there may be with the property. Of course, that is in the best interest of the consumer, in this case being the buyer, who would then be able to have line of sight of any defects or issues that there may be with the property before the sale is concluded. And if a property practitioner fails to do so, they themselves can actually be held personally liable and actually face some kind of process by the authority. And I think what's also very important from a consumer protection perspective is the process around lodging complaints. So again, the regulation seeks to outline the mechanisms that consumers can actually follow, the processes that consumers can follow if and when they actually have complaints against property practitioners. So this information will be available presumably on the regulator's website. They can download the forms and ensure that they provide the relevant information. And the regulator is required to, once a complaint has been lodged, they are required to open a case, provide a case number within 7 days, and then actually give a way forward in terms of mediation or arbitration of the issue. Another area that I believe is a very important change in the new Act is, of course, you've mentioned the question of transformation. The new Act provides a very clear framework for how transformation is to be implemented and funded in the sector. And I think that's something that is absolutely monumental and which is unheard of in many other industries. The sector is very intentional about wanting to increase diversity and representation of those who practice in the sector and those who own property and those who develop property in the sector. So that is an area, again, where we also look to consumers to join us on this journey and actually be part of supporting practitioners who are part of the so-called historically disadvantaged groups. And lastly, the Act seeks to provide mechanisms that will improve ease of doing business and reduce the costs of compliance in the sector. And, this is obviously something that is a national agenda. In the President's Economic Reconstruction and Recovery Plan, one of the key elements that we are trying to achieve as a country is to improve our ease of doing business score. And indeed, this Act speaks to that, in that a lot of the compliance hurdles and barriers that under normal circumstances would drive people away from our sector or would make it very difficult for those within the sector to comply, a lot of those barriers have been either reduced or entirely removed. And again, we can touch on more of that later.
Vuyiswa, this law also requires that any business earning a commission or a brokerage from the sale or lease of a property, they are required to hold not just a valid Fidelity Fund certificate, but a tax clearance certificate and a BEE certificate as well. Why is this significant?
It's absolutely significant. Practitioners have always been required, well, estate agents in the past have always been required to be in possession of valid Fidelity Fund certificates. The Fidelity Fund is a fund that exists for the purpose of protecting consumers. So where they are, and it applies to those practitioners that are in the business of deposit taking. So whether you're talking about a rented or leased property, or you're talking about a property that is being sold, often the practitioner themselves is responsible for actually holding those funds. And in the past, there have been instances where those funds have been misappropriated. Deposits have not made their way to where they were supposed to be going, to the seller or to the transferring attorneys, and thus this mechanism exists for that purpose. So if and when funds are misappropriated, consumers again are able to file a complaint and lodge a claim against the Fidelity Fund. And it's so important. I mean, one of the other areas is that practitioners are required now to publicly display their Fidelity Fund certificate and registration information. And again, I encourage consumers to hold us accountable to that. When you transact with practitioners from the sector, ask them where their Fidelity Fund certificates are. Check if they are registered agents and if they are practicing legally, because that also then ensures that you have a level of protection in the case of any kind of malfeasance. You mentioned also the BEE certificates and tax clearance certificates. Of course, this pertains to companies, not individuals per se, but as a company, as part of the transformation journey that the industry is on, triple BEE certificates are now a requirement. Tax clearance certificates, of course, are also a requirement. We want to ensure that those who are engaging in the industry are of the utmost highest ethical standard.
Vuyiswa, this is part of the raft of changes that have come through, and it's something that is quite important. If you are a home buyer right now and you end up dealing with an illegal estate agent unbeknownst to you, you can end up having loads of trouble and owing lots of money just for dealing with an illegal estate agent. There are new regulations on that front too. Tell us about those.
Well, of course, there are numerous agents actually who are trading illegally. And unfortunately, some of these agents have been almost forced into trading illegally because of some of the high compliance issues that I referenced earlier. There are, however, a number of other estate agents or practitioners in this case who perhaps are illegal or trading illegally because of prior criminal records, etc., etc. So the new act essentially says that it provides for regularization of illegally trading agents, in that what it says is that those who are willing to come back to the fold and rectify their status will be given an opportunity to do so, and an amnesty of sorts to be able to get themselves back up to the level. And this is important because as a consumer, as I mentioned earlier, you need to ensure that you are dealing with someone who is regulated and who has the correct certifications, because that is your insurance policy as a consumer. Failing which, you have no recourse if something goes wrong. As I mentioned, the issue of trust accounts, etc. Those who operate outside of the regulatory framework, it's very difficult to hold them accountable to the standards that are upheld in the sector. And of course, they give the rest of the sector a very bad name. So, and Xolani, just to go back to my previous comment, it is more than just about estate agents now. I mean, a lot of consumers buy property directly from property developers, for example. And there's often a number of complaints that arise from those who buy directly from property developers. But now, developers who are in the business of selling property will also be regulated. And that is quite a monumental achievement, and it really represents progress in the sector, because there will be some level of recourse and control of the transactory environment.
Vuyiswa Ramokgopa, the chairperson of the National Property Practitioners Council, giving us the lowdown on the new property laws that seek to protect and transform the property sector in this country.